All right, let's go on the record on DC 234202 Nava versus UCARS Management LLC. Counsel, make your appearance.
Jody Neal for Plaintiff Lizette Nava.
Brian Pollard on behalf of Lyft.
Clark Butler on behalf of defendant Stephen Bogle and Smyrna Ready Mix Concrete LLC.
Jamie Sala on behalf of Lizeth Nava and Cameron Townley as intervener defendants.
All right, you may proceed.
Your Honor, Brian Pollard on behalf of defendant Lyft. Lyft has filed both no evidence and traditional motions for summary judgment of all the plaintiff's claims. Plaintiff did file a third amended petition late on Friday. I don't know if it's been accepted by the clerk yet. Lyft would object to that, but at the same time, the new claims pled in the third amended petition fall within the scope of Lyft's original motion for summary judgment anyway, under the Gibson case out of the Dallas Court of Appeals. So it may just be more efficient to have everything heard today anyway. To back up, Your Honor, this case involves an October 25th, 2022 auto accident on I-35. The defendant driver, Michael Gillard, rear-ended plaintiff's vehicle. Plaintiffs assert that Mr. Gillard was an employee or agent of Lyft. They assert respondeat superior claim, and they also assert negligent hiring, negligent supervision, training, and retention, and they also assert a negligent entrustment claim. Lyft challenged all of these claims on no evidence grounds, and particularly with the most critical element for each of these claims, since they're based on employment or agency, plaintiff failed to present any evidence that Mr. Gillard was an employee of Lyft. In fact, they can't prove that, but what they do try to do is they try to push that burden over to Lyft to prove that Mr. Gillard is an independent contractor, which Lyft has done. Can I share my screen, Your Honor?
Sure.
You can see that, Your Honor.
Yes.
Under Chapter 2402 of the Texas Occupations Code, drivers of transportation network companies like Lyft are independent contractors for all purposes and not an employee of the company in any manner. Lyft has proven up that it is a transportation network company, more commonly known as rideshare companies, and filed as evidence its permit to operate in Texas as a transportation network company. Lyft has also proven up that Mr. Gillard was an independent contractor under Section 2402114 of the Texas Occupations Code. And you'll see that there's essentially 5 elements that must be proven up. Plaintiffs essentially concede that subsection 1, we meet all these elements with the declaration of Lyft's corporate representative, Mr. Alex Snegowski. I always have a hard time pronouncing his name. What they do challenge is subsection 2, whether Mr. Gillard and Lyft agreed in writing that he's an independent contractor. This is contrary to the Rosales case, which is out of the Southern District, Federal U.S. District Court, Southern District of Texas, which is a case involving both Lyft and Uber. What plaintiff cites is the Aerotech case and says that Lyft failed to prove up security procedures showing that there was an agreement with Mr. Gillard. In the Rosales case, let me pull it up here. The court addressed this very issue and found that under Aerotech, as long as the defendant proves that the person using the platform has to agree to the terms of service in order to use that platform, then there's proof of agreement under Aerotech. And Mr. Snegowski's declaration that Mr. Gillard, in order to use the Lyft application as a driver, had to click I agree to the terms of service. He also had to scroll through the terms of service before he clicked I agree. And that in and of itself proves agreement. But on top of that, like in Rosales, Lyft has proven up the terms of consent log for Mr. Gillard, showing that he agreed to the terms of service 7 times. And within those terms of service, as the court will see in our, which are attached to the motion for summary judgment, it is shown that they agreed that Mr. Gillard was an independent contractor and not subject to Lyft's direction or control. To try to establish their negligent hiring of an employee or even their negligent hiring of an independent contractor, plaintiffs attached a driving record abstract for Mr. Gillard. That squarely falls within the Farrar case, which it's a Dallas Court of Appeals case, Farrar versus Lyft. In fact, Your Honor, every argument plaintiff makes in their response falls within the Farrar case, which is squarely on point and supports summary judgment for Lyft in this case. It's the first case that addresses the independent contractor provision of Chapter 2402, and in fact, the offenses and convictions listed in the driving record abstract for Mr. Gillard are directly analogous to the offenses for the driver in the Farrar case. Where the evidence fails that plaintiff has submitted to the court is the fact that under the occupations code, to be disqualified as a driver, there have to be removing violations. There has to be 3 convictions, not driver's suspensions or anything like that. There has to be 3 convictions in a 3-year period before the background check. And there are no 3-year convictions within 3 years before this accident or 3 years before Lyft approved Mr. Gillard for using the platform as a driver. For a criminal history, there have to be convictions within the preceding 7-year period. There are 2 offenses listed within a LexisNexis, what I think is a LexisNexis background search, but it's incomplete. Lyft has objected to that. Lyft has also objected to all of plaintiff's other exhibits and filed that with the court. But specifically, even if the court were to consider this LexisNexis background check as valid evidence, all it shows are 2 offenses that one of them was dismissed. The other one, you can't even see a disposition on it. And both of them fall outside of this 7-year scope.
Anything
As
else?
for plaintiff,
Oh, sorry, go ahead.
that's for plaintiff's negligent entrustment claim, Your Honor. For Lyft to be liable for negligent entrustment, it would have to own or control the vehicle Mr. Gillard was using. Both Lyft and plaintiff have submitted to the court the accident report that shows UCars on that vehicle. And therefore, that evidence in and of itself precludes their negligent entrustment claim. They try to argue a joint enterprise somehow between Lyft and UCars without any evidence showing it. And with the only evidence they submitted being from UCar's corporate representative saying that he's aware of no contract between Lyft and UCars. The additional claims that plaintiff asserts in their 3rd amended petition fall squarely within the same arguments. They argue joint enterprise, which the Acosta versus Uber case says falls within the same arguments. And in fact, any joint enterprise arguments precluded because the chapter 2402.114 makes it very clear that the drivers are independent contractors for all purposes and not an employee of the company in any manner. And in the Acosta case, the El Paso Court of Appeals held that that precludes a joint enterprise claim as well. And then plaintiff's remaining claims in their third amended petition are negligent hiring of an independent contractor, which Lyft already addresses in its motion for summary judgment, and a negligent undertaking claimed upon background searches, which is also addressed in Lyft's motion for summary judgment. Therefore, Lyft requests that summary judgment be granted.
Response?
Good morning, Judge Hoffman. This is Jody Neal here. I noticed in to try this case in August and began to review the file and noticed that there were many deficiencies in the discovery. What we have here from defendant Lyft is a corporate defendant who reaps many benefits of doing business in Texas, but is effectively litigating a special exception in a motion for summary judgment. They have not responded to discovery, fulsome responses. They have quashed the corporate rep deposition. And as to their main points on this argument, the Texas Transportation Code, we dispute that they've met the elements indicating that the defendant Gillard was an independent contractor. We tried to take the corporate rep deposition and it was quashed. We appealed it. And again, we were not able to take the deposition. So Lyft has effectively, they refer to electronic files, the defendant hitting agree. They refer to the defendant being logged off, and there is no e-discovery in this case. We have only screenshots and affidavits for which we are unable to do cross-examination. We are asking that this be denied or that it be continued. We have filed a motion to compel, I have, to obtain e-discovery in this case. If they're going to refer to electronic signatures and electronic files, we need the entire file. Screenshots will not suffice. I attempted to set up a meet and confer. The defendant did not respond. I sent a deficiency letter and there was no response. Additional discovery is needed on this case, and we're asking the court to either continue this hearing to allow for additional discovery or to deny it.
Response?
Yes, Your Honor, this case was on file for 16 months before plaintiff joined Lyft into the case. They never conducted any non-party discovery on Lyft. The deficiency letter she's talking about was sent to Lyft, was sent to me like 2 weeks ago. The discovery period's ended. She complained that Lyft quashed the corporate rep deposition, but it was the court that quashed the corporate representative deposition. Plaintiff never sought mandamus relief, and they've never asked again or noticed this corporate representative deposition since then, which was early this year in January and February when the court considered whether to allow Lyft's corporate rep deposition. The first notice I've ever had that they have complaints about our interrogatories, as they state in the response, was 2 weeks ago. And none of that is relevant to this motion for summary judgment. None of those interrogatories are relevant to any evidence that could contest a summary judgment.
Mr. Pollard, you cut out there at the end. What did you say?
None of the discovery they are seeking are relevant to whether to the issues lined out in this motion for summary judgment.
Okay, you said that this, Ms. Neal, that this had something to do with a special exception, that they're basically litigating a special exception. What do you mean?
It's as though they have come in and they've basically said, no, we're not participating in discovery. It's like they're doing like a jurisdictional, like we're in jurisdictional discovery where Lyft has specifically limited what they're willing to answer and what they're willing to give us. All they're saying is, no, he was not an employee. He wasn't an independent contractor. Oh, and also these are not the droids you're looking for. You can't have any of the underlying files, any of the electronic files, because he wasn't logged in. I mean, you can't even have the insurance policy because he wasn't logged in. They're using electronic methods to narrow the scope of discovery so that they just don't have to participate. They have effectively not participated in discovery. We don't have anything that we need to effectively defend ourselves on a motion for summary judgment. Most of what we've gathered has been from the open source, from the internet, to respond to this motion. Even still, they cannot say that there's not a scintilla. The defendant himself in the hospital gave an interview to the police where he says that he was driving for Lyft. This is a 7-minute window of time. You'll see from our response to the motion for summary judgment.
Your Honor, He does not say, he does not even mention Lyft at all in that recording.
Yeah.
Plaintiff submitted as Exhibit A, the recording. Lyft is never mentioned at all. The
That is
only,
not true.
that is true.
I would invite the court to watch it.
Yes, me too. Lyft is never mentioned in that recording.
I've watched
Hey.
it before. I mean, he does say that he was, I don't remember if he says the word left, but he does say that he was on a job or something like that. I don't remember the exact wording, but why are you, is there some, does he not exactly say the word left? Because he, in the recording, he does say something like that.
He says U cars. And he actually says he was done with work and he was heading home at the beginning. To the extent
That's
you
not
can figure out
accurate.
what he meant.
That's not accurate.
Must have a different recording then.
Well,
Why don't you
what
say
you
that-
have is all the evidence that you won't provide in discovery.
Okay.
I mean,
Your Honor, if I may speak to the screenshots she's talking about, and even what she's talking about with Exhibit A, those go to course and scope. All of that's unnecessary given the fact that they failed to prove that he's an employee. All of their claims fail because he's, one, not an employee, and two, because we have proven up that he's an independent contractor statutorily.
To that point, Your Honor, Lyft is required by law to keep track of 12-hour driver periods. Point 1 of Chapter 2402 of the Texas Occupation Code says the company does not prescribe the specific hours during which the driver is required to be logged into the company's digital network. They can't have it both ways. They either have to make sure that he is complying with federal guidelines by complying and adhering to the 12-hour rule, which requires Lyft to know on their back end, and they will not disclose the name of the system. The back end system that tracks how long drivers are actually working for Lyft, because there has to be a 6-hour break in order for Lyft to comply with the federal guidelines.
Your
So
Honor,
they can't have it both ways, Judge. They can't.
she's not even reciting evidence before the court. First of all, she's talking about
I am reciting my response.
If I may finish.
If I may
she's
finish, you
misconstruing
interrupted me first.
yeah, Mr.
We
Pollard.
produced with. Yes.
So guys, what I'm going to do, I'm going to go ahead and review all this. We'll try to get you an answer as soon as possible. I mean, Ms. Neal, I appreciate you made a valiant effort here. I do. A lot of the requests I think you made were after the discovery period had closed. Is that why I quashed the deposition? I don't recall why I quashed the deposition.
I think it was on the
Yes, okay.
merits. I don't think it was because, but the motion to quash is in the record. It's in our response to the MSJ.
Your Honor, I believe the associate judge quashed it and then they appealed and you affirmed it or overruled the appeal.
Okay. I'll review this, try to get you an answer by the end of July. You guys have a great rest of your day, okay?
Thank you. You too.
Thank you.
Appreciate it.
Okay. Let me talk to the interns real quick. They're online. All right, Tony, our next hearing, let me just. So we have a trial setting tomorrow. So you guys will come in tomorrow. Try to get here by, you're gonna have a short orientation by our senior intern tomorrow morning, who has been through this orientation a few times. So you guys will come in. Claire, you've already been through it, so you don't need to be there until 8:45. The other interns get here at 8:30. And then we have hearings this afternoon that you'll sign back on for. Let me just make sure it's at 1:30. Oh, the next hearing's not till, yeah, it's at 1:30. So go ahead and sign back on at 1:30. Why don't you each introduce yourselves, those of you on Zoom, and then if the interns, if you guys want to come over here, you can introduce yourselves as well. So we'll have the interns on Zoom introduce themselves first.
I'll be back at 1:30, Judge.
All right, thank you.
I guess I can go first. My name's Anika Tansen, and I am 16 and I go to Hockaday. And I'm really excited for the chemical case that's coming up in the coming weeks.
So it'll be for the next 2 or 3 days. So good to see you. Nice to meet you again.
I can go next if you want, Judge.
Yeah.
Hi, my name is Claire Taylor. I'm an incoming junior at Pepperdine University. I've been with Judge already for a week, starting my internship, so I'm super excited to meet all of you guys and see some familiar faces. Also, Judge, am I supposed to be in today?
Oh, I don't know. You can come in. You just come in tomorrow. It's fine.
Okay, sounds good. Nice to meet all of you guys.
Ms. Hong?
Yes, hi. I'm going to be a junior at Creekview High School, and I'm 16 as well, and I'm excited to intern with you.
Right. Mr. Smith?
Yes, my name is Isaiah Smith. I'm currently getting my master's at Texas Tech, and I'm more than excited to intern.
Right. Mr. Morella?
Hi there, my name's Anirudh Morella. I'm a third year at Vanderbilt University, and I'm excited to be here. Thank you.
Mr. Gonzalez? Mr. Gonzalez? Nico Gonzalez? Okay. Oops. Oh, we're on Zoom on YouTube. I didn't mean to do that. Let's see.